The Criminal Law and Procedure Evidence crossover question from July of 1986 affords us an opportunity to review a number of issues that you've seen elsewhere in these seminars. It also gives us a chance to use all of the techniques that we've been working on once again in order to create a well-organized outline and a very clear answer. These issues presented in this essay are ritualistically tested here in very much the same way they've been tested before and since. And the criminal law aspect of this fact pattern actually is somewhat more commonly tested on the multi-state. So the language will be familiar, but you've only seen them in one or two other questions that we've reviewed together. Take a look at the call of the question, and we can anticipate quite a bit of the organization that will follow. 1. Did the court err in admitting Ace's statement, A against Ace, B against Bert, C against Chuck? Discuss. Well, we can intuit that this is a criminal law and procedure question, given that statements are being admitted against, a statement being admitted against several different people. So we know in call of the question 1 that we're dealing with evidence. And we know that the basic structure of all evidence analysis on essay questions is logical relevance, objections, and then a conclusion about admissibility. Since we can intuit just from the structure of this call of the question that we're in criminal court, there's a good chance that there will be Fifth and Sixth Amendment issues presented too, and perhaps Fourth Amendment as well, given that Crim Pro is really testing the Fourth, Fifth, Sixth, and Eighth Amendments, and the Eighth Amendment doesn't really apply to evidence issues. So that's our reaction to the first call of the question. The second call of the question reads, would proof of the conduct described above be sufficient to sustain the convictions of A, Ace and Bert for theft? Discuss. B, Chuck for attempt to receive stolen property? Discuss. Well, here we know the basic elements of those crimes, but what it's going to boil down to is we've got to connect the facts from the pattern to those elements in order to figure out whether or not liability should attach. Go to the top of the fact pattern, and here, once again, the comparisons between the language used here and many criminal law multi-state questions is kind of hard to escape. Paragraph 1. Ace and Bert, our first two named defendants, needed cash quickly. They offered to sell Chuck a watch, which Bert told Chuck was worth $250, but was stolen and therefore would be sold for only $25. Chuck believed Bert, gave him the $25, and received the watch. Both Ace and Bert knew that the watch was not stolen and that its retail value was $25. Well, turn to the very last call of the question. Let's just isolate the facts in this paragraph. Is that good enough to convict Chuck for attempt to receive stolen property? Sure it is. He had the correct mental state. He engaged in an action to try to further that target offense. So, just based on the first paragraph, our answer to the last call of the question is yes, although obviously we're going to have to analyze the facts and be alert to see if anything else in the pattern changes our mind about that conclusion. In paragraph 2, we find out that Chuck is a loser, and we also find out that this is kind of an artificial fact pattern. Okay, Chuck finds out the watch is worth only $25. He reports the incident to the police, and so the cops get warrants and they arrest not only Ace and Bert, but they also arrest Chuck. Okay, I've spent enough time in the criminal justice system to know that Chuck is a loser, but maybe this question isn't so artificial. I remember a client who was arrested for trying to sell drugs to an undercover police officer in a police station. Okay, end of digression. So, all three defendants are arrested. They're all Mirandized. Anything you say can and will be used against you in court. You've got a right to consult with counsel before questioning. If you can't afford a lawyer, we'll give you one. Fair enough. Now, none of the three made any statement at the time of arrest. So they received their Miranda warnings, they understood them, they did not give statements. Later, at the police station, when a booking officer, a neighbor of Ace, asked Ace why he was there, Ace stated that he and Bert had, quote, conned Chuck into buying a watch by telling Chuck that the watch was stolen, and Ace and Bert were selling it to him cheap. All right. This defendant was in custody, but this question was hardly a custodial interrogation. So the earlier Miranda warning is valid, and it looks as if the statement is voluntarily made and not a response to a custodial question. Incidentally, the examiners were content with either interpretation. What they were most interested in was issue spotting and analysis, here as just about everywhere else. Then the final paragraph, Ace and Bert were charged with theft. Chuck was charged with attempt to receive stolen property. Now, here's where the court makes a significant error, or at least creates problems for itself in the laws of evidence. All three defendants are tried together. Ace's statement was admitted in trial over the objections of each defendant, and each was convicted as charged. Well, it looks as if none of the defendants have testified on their own behalf. So, let's turn the page for a moment after we acknowledge again the call of the question. Now let's have a look at the way that I suggest we organize our answer. Look at the outline of issues. And here, you'll see that the core of the analysis with regard to the statement is we follow the evidence format. We have the statement being used against Ace and Bert and Chuck. Internally, we focus on logical relevance first. Then we focus on the objections. With regard to Ace, there will be a Miranda objection based on the Fifth Amendment. Also, a hearsay objection, although, as you probably already intuit, an admission is not hearsay under the federal rules, and it's an exception elsewhere. Next, we consider Ace's statement used against Bert. Bert can't contest Miranda because Bert's rights weren't violated. He can't bring the same hearsay objection, and it will meet with the same result. It'll be denied. But then the Sixth Amendment right to confront comes into play. And here, because the three are tried together, and because Bert can't compel Ace to take the witness stand, the Sixth Amendment right to confront is going to prevent the statement from being used against Bert. And similarly, the analysis for Chuck is more or less identical to the analysis for Bert. Chuck also has no standing to contest Miranda. There's a hearsay objection and a Sixth Amendment right to confront. So the organization is identically the same as it would be under other evidence problems. And remember, in our evidence seminar, we looked at a couple of criminal questions with evidence issues, and one or two of them involved the Sixth Amendment right to confront. So now we turn to the criminal law aspect of the question. Is the evidence good enough to sustain convictions? And then we organize around the charges. With regard to the charge against Chuck, notice that I have internal organization for attempt being a specific intent crime and Chuck offering a mistake of fact defense. So this is an answer that's easy to organize if you keep your wits about you and remember that our basic approach to outlining crossover questions is to recognize the part of the outline that the element is testing and then just apply the approach that we use in that area of law when it's being tested alone. The result? We were able to create short answers out of an essay pattern. So now, let's take a look at the answer briefly. And here, I think you'll see, again, this is very similar to questions and answers you've seen before. So, the first question, did the court err in admitting the statement? Notice that I lead with the facts. I explain what the testimony is. Ace told the booking officer that he and Bert had conned Chuck into buying a watch because they told him it was stolen. And you'll notice that in the introduction, I indicate that Ace knew the booking officer because they were neighbors, but that he was under arrest and at the police station when he made the statement. Now I focus on the evidence analysis. Ace's statement used against Ace. It's relevant because it shows that all the defendants are guilty. Next, I focus on Miranda, and here I indicate that the Miranda warning appears to be valid, except for the fact that it fails to mention the right to remain silent. So, if the statement is offered as a result of a custodial interrogation, this technical deficiency in Miranda is likely to keep it out. But notice, although Ace was in custody, the booking officer knew Ace, and it was not a question asked with the intent of eliciting an incriminating response. So, since the booking officer wasn't an interrogator, the statement should be admissible against Ace. Next, we turn to hearsay. You'll notice that I define hearsay more or less up front, but as an admission, this is non-hearsay federally. It's an exception in the states. Next, we turn to the statement of Ace being used against Bert. Here, I lead with what Bert has to prove, that either his rights or the laws of evidence would be violated if he wants to keep the statement out. Notice that Bert was not challenging the statement based on Miranda grounds. He can't, because although Miranda were imperfect, the warnings he got were imperfect too, Bert was never interrogated, and hearsay, again, is an exclusion from hearsay, which would be admissible against Bert. Also, I point out that the statement that Ace used that we are seeking to quote was not made in furtherance of the conspiracy, so the co-conspirator exception doesn't apply too. That's a real fine point that you didn't need to get a passing score. Next, we focus on the Sixth Amendment, right to confront. And here, we've got a defendant who wants to sever his charges from the others and fails to do so, and now Bert can't force Ace to the stand because it would violate Ace's Fifth Amendment right against self-incrimination. But the Sixth Amendment right is the one that will keep Ace's statement out of the trial against Bert. Next, we focus on Ace's statement used against Chuck, and here the analysis is the same. I use the same headings. I have much less to say because I've already said it before. Then we focus on the criminal law aspect of the question, and here it's pretty simple. The answers are simple, and the analysis comes pretty quick and easy. It's very similar to a multi-state problem. We look at Ace and Bert and their theft charge. What they've tried to do here is engage in false pretenses in order to get money from someone by lying to him about a transaction. And that's good enough to convict him. Next, we look at Chuck's charge. And we see here the analysis has to be a little bit more complicated in order to do a really thorough job. Chuck is charged with attempt to receive stolen property. This is a specific intent crime. I focus on the facts and on the mental state of Chuck. Then we turn to his mistake of fact defense, but sadly for Chuck, it isn't good enough to win him an acquittal because his evil mental state, his criminal mental state, is enough, combined with his actions, to convict him of the charge of attempt to receive stolen property. And that concludes what I think is a very straightforward crossover question. If you've got a pretty sharp idea about how to approach evidence, and if you are able to think clearly about a somewhat complicated fact pattern, you can resolve it in time, and you can create a well-organized, thorough answer.